Okay, friends, how are you? I hope you are having a good time in gaining this knowledge. As we are under the progress of gaining knowledge, I think in times to come, you are going to capitalize on this particular knowledge. And with IBC playing a major role in the turnaround of the economy also. So I think you have a good future in times to come. So let's get prepared, friends. As I've been discussing in a lot of other forums, friends. Yes, I focus more on creating positivity in ourselves, and uh, probably knowledge is one way to create that positivity within ourselves. Okay, so as discussed in our last session, that we'll be covering shorter portions of those cases of or sections of IBC where they are very vital in execution of the whole process of CRP, and at different point of time they are being referred to. So today we'll be covering an important part, friends, that is regarding the type of transactions which has to be covered by the RP or the liquidator in the course of CRP or liquidation. And these are very quite commonly referred to and discussed at different stages as well as in the NCLT, because these are some important transactions which actually tells us the reason that why company went into insolvency, or was there any particular transaction which were purely done to defraud the creditors and so on. So that is why they have been taken separately in IBC, and separate provisions are there to understand the type of transactions and then the consequences if these transactions are found out, friends. Okay, so let us go ahead and understand the types of transactions. So we will be covering the preferential transactions, the undervalued transactions, the fraudulent transactions, and the extortionate credit transactions. I think each particular transactions will be well defined under various provisions, and these are covered for different time period as the scenario or as the case progresses. And when the RP comes to know about these transactions, then they can order separate audit or transaction audit for these, finding out these type of transactions. So first is section 43. So probably this will be covering 43, 45, 47, 46, 66. These are specific sections targeting on specific areas of transaction. So let us understand first the preferential transaction. What type of preferential transactions? Basically, it covers transfer of properties or any interest thereof during the relevant time to a person for the benefit of creditor, surety, or guarantor on account of any antecedent debt or other liability. And such transfer having the effect of putting such creditor, surety, or guarantor in a better position. So in simple words, that means where the corporate debtor has entered into a transaction which have favored a particular creditor, and this may have given certain benefit to that creditor in comparison to the other creditor. That type of transaction will be known as a preferential transaction. Creditor can be what? Operational, financial, as the case may be. Now, till what particular time period we can go back and trace these particular transactions is the relevant time. So it tells about for a related party, the transaction is between a related party, other than the reason of only being an employee, 2 years preceding the insolvency commencement date, or for any other person, it is just 1 year. So till that time, we can go back and find out these transactions. And if these transactions are referred to in any particular report, then the order can be that they will require any property which is transferred in connection with the giving of the preferential transaction. Then they'll require that particular property to be transferred back to the corporate debtor. Then a release or discharge of any security interest created by the corporate debtor, and require any person to pay such amount in respect of benefits received by him from the corporate debtor as the NCLT direct, or direct for providing security charge or any for discharge of any financial debt or operational debt under the order. So it depends upon case to case. So the law says that yes, if there is any property which has been vested, they have to be referred back. If there's a security interest which has been created, they have to use or discharge that. And if any sum has been received in such benefits, then obviously as whatever the NCLT will direct. So preferential transactions giving preference to a particular creditor, and because of that, the relevant consequence can happen. Next, we come to undervalued transactions. Now, what we all understand is undervalued is those transactions where the transaction have been done in comparison to the market price at a lesser value. So it can be a gift to a person. It can be a transaction with a person which involves the transfer of one assets by the corporate debtor for considering the value of which is significantly less than the value of consideration provided by the corporate debtor. That means purely simple in meaning means less than the fair value of that particular asset or the transaction, giving that the transaction had not been entered into an ordinary course of business, which highlights that this transaction was not done in an ordinary course of business. So that is an undervalued transaction. Relevant time, again, for a related party, you can go back to 2 years, and non-related, you can go back to 1 year. And then what can be the order can be issued by the A. Then they require any property transferred as part of the transaction to be vested to the corporate debtor. So that means the property will be transferred back. Release or discharge of any security interest. Then it may require the person to pay certain sums in respect of the benefits as directed by the NCLT. So again, as I said, though the law has been very general, but when you go to case, relevant case, I think it can be different scenarios for each of the case, and accordingly the order may be released. So that is the second transaction, that is undervalued transaction. Moving ahead, I think the third type of transaction is avoidable transaction. So in an application for avoiding a transaction at undervalue, the liquidator or the RP, as the case may be, shall demonstrate that such transaction was made with any person for 1 year, or a non-related party. For related party, it was 2 years, that we have already discussed. So relevant period for avoidable and the undervalued transactions are the same. I think they are more or less the same type of transaction. Yes, very important, friends. There may be a situation where these transactions are not found out by the RP or the liquidator. It may happen. So in that case, what can happen? The members can report the same kind of transaction, and they may refer it to the adjudicating authority to declare such transactions void and reverse their effect. And where the A, after explanation of the application, after examination of the application, and is satisfied that there's another value transaction has taken place, then he will inform the R or the liquidator, as the case may be, to call upon the liquidator or the RP to give information of such transactions, and then issue an order and restore the position as it existed before such transactions and reversing the effects. And then, yes, because the RP has not done his job properly, so the case may be referred to the board for the disciplinary action. So this is about in these cases where the RP does not report it to the adjudicating authority, and one of the members of the committee, COC, goes and files an application. Then we come to another important section, that is section 49, which talks about transactions entered with the intention of prejudicing the interest of a person who has made or make a claim against the corporate debtor. That means where the transaction had been entered so that the intention is to defraud the creditors, putting an interest of particular person who has made a claim against the corporate debtor. So that is the whole objective, is that yes, the payment has not to be made to the creditor. So that is the whole objective. So the orders can be restoring the position as it existed before such transaction, as if the transaction had not been entered into, and protecting the interest of the person who are victim of such transactions, right? So basically the objective is that we have entered into a diversion of fund, or it can be siphoning of funds, or any other case where we feel the creditor feels that the purpose of that transaction was to defraud the creditors. Then there are the extortionate credit transactions under section 50, though it is not defined in the code. So again, it is left to the IBBI to decide upon it. And the relevant time is 2 years preceding the insolvency commencement date. And the orders are very exactly similar to what have been there in the previous sections of restoring the original position as if these transactions did not take place. So as of now, if you see, there are cases under section 43, 45, and the recent JP case has exactly enumerated that under what circumstances 43 and 45 could be invoked. But yes, for 50, I think no such major section has come here, so that the relevant, laws can be reframed and specific definition could be introduced under section 50. And the last of the section is again very important, that of fraudulent transactions under section 66. And if during the CRP process or a liquidation process, it is found that any business of the corporate creditor has been carried out with the intent to defraud the creditor. So once the RP comes into the picture and finds that there were transactions with the intention was to defraud the creditors of the corporate debtor or for any fraudulent purpose, the AA may, on the application of the RP, remember, so the RP has to apply, pass an order that any person who were knowingly party to the carrying of the business in such manner shall be liable to make such a contribution to the assets of the corporate debtor as it may deem fit. So instead, they may come up with an order telling that you have to contribute this much amount to the assets of the corporate debtor. So remember, the application has to be made by RP. So then the AA may direct the director or partner of the CD, as the case may be, shall be liable to make such particular contribution. So these are very important sections, friends, which actually forms a crux of allegating or blaming, putting up a point that yes, the suspended management of the corporate debtor did not function well, and there were certain transactions which were subject to question, and that is why these provisions have been introduced, so that the RP has got the facility, the leverage, or to refer these kind of transactions to the A and leave it up to the adjudicating authority to decide on the matter and take appropriate action. So very important, and this casts a very big responsibility on the RP to carry out the process of CRP very diligently and ensure that these transactions, if they are found out during the course of CRP, they are referred to the committee and thereafter to the respective adjudicating authority to call for further action. Right. So here we come to the specific transaction-based sections covered under IBC, and very relevant, right? And beyond that, there are no such transaction, friends. So here we stop with another short session on the IBC Code 2016, and again we'll be meeting up with again a short video on specific topic of punishments and fine under IBC. Till then, goodbye, friends. Thank you.